The first matter to come before the court this morning is State of Ohio versus Brady M. Phillips. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and would like to reserve some time for rebuttal, if you let me know when you get started. I'm keeping the clock this morning and can keep you apprised of the passage of time. We've read the briefs and are ready to proceed when you are.
Wonderful. Good morning, Your Honors. May it please the Court, Attorney Brian Darling, on behalf of the appellant Brady Phillips, I'd like to reserve 3 minutes for rebuttal. So this case is kind of an interesting case because the appeal that I filed is really pertaining to a civil issue inside a murder case. The case is not resolved, and what we have done is Mr. Phillips participated in what we have described as cooperation agreements, and what the trial court found were binding contracts with the prosecutor's office about really his cooperation involving two cases. The one that he was indicted for, the prosecutor's office was interested in some information on who set this burglary turned murder up. And the second cooperation agreement involved some information Mr. Phillips had with respect to an unsolved murder that occurred in Lorain, Ohio several years back. They met, they recorded the meetings, they being the prosecutor's office, defense counsel at the time, and Mr. Phillips, and they recorded their discussions, what was going to be agreed on. And then it wasn't, Mr. Phillips started to perform. He went out back to the jail and surreptitiously recorded a conversation with one of the suspects in the unsolved murder in Lorain. And he also performed with respect to disclosing the name of the individual who set up the burglary turned murder in Elyria. But the prosecutor's office decided not to honor the proposed agreement, which was kind of a stair-stepped agreement. It was initially described as, give us information on who set up the burglary turned murder, and for that, we're willing to agree to a 14-year sentence. Then Mr. Phillips came back and said, well, what would you give me if I gave you information on the unsolved murder? And they said, if you gave us information on the unsolved murder, we'll agree to a 6-year sentence. A pretty good deal for both parties. So what was the deal exactly? The deal wasn't honored by the prosecutor's office, so what I did was when I got in the case, I filed a motion for specific performance. We had a hearing. The judge reviewed the recordings. So the judge found, yes, there were agreements on both. But did Mr. Phillips perform? The judge found he performed fully with respect to cooperating on the unsolved murder in Lorain, and that the prosecutor's office even agreed that he should be given full credit. For that, the judge sort of picked a number of 14 years based on some experience in the past of cooperating in unsolved murder cases. But he didn't agree that Mr. Phillips fully cooperated with respect to disclosing the information on the case Mr. Phillips was involved in. But here's where the trial court erred. The trial court interpreted the agreement as, Mr. Phillips, you need to give information to the prosecutor's office, which you did. But what you also needed to do was you needed to have your wife's statements, who also cooperated, your wife's statements need to be corroborated as well. That was never discussed on any of the tapes. They're transcribed to be part of the record for your review. Based on that, the trial court declared that Mr. Phillips did not fully perform on the second deal, which was fully disclosing information on who was behind. He gave all the information he had. And the weird thing about the wife's involvement was she agreed to cooperate. She gave statements that corroborated Mr. Phillips' statements. She was also asked if she were willing to attempt to surreptitiously record the quote-unquote mastermind behind this home invasion turned murder. She initially agreed. The problem was she expressed a lack of knowledge as to what that person's phone number was, so she needs some help. The police didn't reciprocate. They never offered that help. They never helped her set up the phone call. Months passed, and she eventually told the prosecutor's office through the Detective Bureau in Elyria PD that she wasn't willing to cooperate. The trial court, though, I think made the mistake of holding that against Mr. Phillips and saying, hey, that was part of the contract, that you were not only going to give what you knew and that your wife was going to give what she knew, but that you were going to have your wife's statements corroborated by some surreptitious recording. The problem is...
Can you back up with the procedure with this? This panel isn't always the same panel that handles docket issues prior to hearing the oral argument. So evidently there was some kind of show cause in regard to final appealability.
Yes. I was hoping you would bring that up.
So I don't have everything in front of me today, but I know at least that we have some preliminary determination that there is a final appealable order, preliminarily anyway, until the panel looked at it.
That's right. Magistrate Walsh brought the question up as to why I thought this was a final appealable order, and I went with subsection D on the jurisdiction with respect to, I viewed this, it's weird because obviously the case is still pending. It's a criminal case is still pending. We haven't had a trial. We haven't had a plea agreement at all. But we had this sort of provisional remedy, which was this, hey, we have this agreement. Judge, do you think we have an agreement? He said, yes, I think you have an agreement. Well, what are the terms? Here are the terms. I think you perform fully here, but partially here.
Why is this any different than any other case where a plea bargain might break down or whatever, that is conditioned on certain conduct or certain acts being taken by a defendant or the prosecution for that matter?
Well, I think you've got, Your Honor, I think you've got performance, a full performance from our perspective by Mr. Phillips.
Well, I guess my point is going to the final appealability issue. If we say this is final and appealable, what's to stop any defendant in the future with a plea bargain saying, making an allegation that there was a plea bargain, that there was an arrangement, and the prosecution didn't fulfill their part of the bargain, and the court just says, no, I don't agree with you, and denies it. But aren't we setting precedents to say that that's immediately appealable?
Well, you may be. You may be. But this was, I think, in my experience in criminal defense the last 10 years, you've got a lot of discussion in this case, and you have a lot of performance with respect to the cooperation. A lot of times, these cases, the plea bargains, if you want to use a more formal term, the plea agreement, it's more, hey, here's what we're going to do. We're going to give you this number of years, and you're going to plead the indictment kind of thing. Here, you've got pretty extensive performance with respect to an agreement. If then, we'll give this agreed sentence. And I think that differentiates Mr. Phillips from a lot of other cases. And it probably surrounds the fact that Mr. Phillips' case was so serious, and the information he was giving was on 2 murder cases. I mean, one that he was involved in, and one that the police were having some difficulty solving.
There's no doubt that this is a very detailed and a lot of back and forth and conditions. But as I've said many times, we don't just decide the cases in front of us. We decide this issue for future cases too. So I guess my concern is if we say this is a final appealable order, like I said, what that means for the future. Let's say just in another case, and this happens quite often, that somebody is to testify against a co-defendant or to provide state's evidence on whatever, and then they feel that the state hasn't lived up to their promises. The usual procedure is if there's a problem with a plea arrangement or a plea bargain, is that you appeal it at the end. You either plead and try to get it withdrawn, or you go take your chances at trial and then you appeal.
That's right. So here, I decided to appeal because I felt, okay, what are the options for Mr. Phillips? So the trial court's saying you're fully performed in part, you partially performed in the other part. We'll give you the 14 years. The prosecutor's going to amend the indictment to make it 14 years. You're going to have to plead guilty to get that because the prosecutor's office was not willing to, they would object to no contest plea, and the trial court informed us that they would not accept a no contest plea. Okay, so what does he do if he pleads guilty? I mean, as in the colloquy, all the colloquies I've ever been part of, you're giving up your right to appeal other than the sentence, you know, and you're displeased with the sentence. So I didn't feel he had a chance with respect to pleading guilty. And then trying to convince this court that, hey, I know he pled guilty, but disregard that. The other part, I guess his option would be to go to trial. And the reason we don't think that's a valid option is because he performed pursuant to an agreement that we feel gets him 6 years in prison. And the trial court just almost got us there, but just misinterpreted what the terms of the contract were. And so I don't think Mr. Phillips really is left with much option. Pleads guilty, he can't get before you. If he goes to trial and is found guilty, then he could appeal, but he doesn't want to go to trial. He wants the contract that he bargained for, which the trial court acknowledges is an enforceable contract. It just misinterpreted Mr. Phillips' performance. He upheld the participation. He recognized his wife's participation, but held it against him that his wife would not participate in the surreptitious reporting that she needed the police to set up, and never did. So our argument is he fully performed in all aspects of the agreement. It's enforceable, and the trial court really just misinterpreted the terms. They're clearly stated in the recordings. Contrary to some cooperation agreements I've been a part of in federal court, which are always in writing, this one's just recorded. But you can. The deal was the prosecutor's office gave Mr. Phillips an option to cooperate, but they wanted information that would give them a prosecutable case. And I think the other error by the trial court was interpreting the strength of the case that Mr. Phillips gave him. The trial court opined that, you know, what you've done is you've really given your statement and you've given your wife's statement, who's arguably a co-conspirator. The wife wasn't involved in the evasion, but she was involved in some alleged tampering with evidence after the crime. But she fully cooperated. And the trial court opined that really wasn't a strong enough case to make it a prosecutable case. It's another error because really we have a nice mechanism to determine whether it's prosecutable or not, so just submit it to the grand jury.
And you're just now reaching your 3 minutes.
Okay.
No remaining time.
Thank you, Your Honor.
May it please the court, my name is Natasha Burry and I represent the appellee in the state of Ohio in this matter. I guess the first thing that I kind of want to go into is the actual agreement or agreements that were contained on these recorded meetings.
So let me start you off though. Is it the final bill of order?
The state would argue that it is not. The entry itself actually anticipates some further action on behalf of Mr. Phillips. It doesn't resolve the case in that Mr. Phillips has not pled guilty, hasn't been convicted, hasn't gone to trial, hasn't been sentenced. So it doesn't resolve the issues that the matter there in this case. So the state would argue that in fact this is not a finable appealable order, that Mr. Phillips does have that option of appealing after conviction if he is in fact convicted.
Does he have the option, as the court seems to say, that to perform fully with respect to the second obligation, and the state would then abide by the agreement, or is it the state's position that they've withdrawn that offer?
In going through the transcripts and looking at all of that, the state initially stated that Mr. Phillips did in fact go forward, complete that surreptitious recording with his cellmate about the Lorain case, and did state that they would go along with the 14-year agreement. They made that available to his initial attorney as well as his current counsel, and they did state at that point, you know, once he's appointed this new counsel, if he accepts it at that point, we will completely go along with that. However, that if he didn't take that opportunity at that point, then the state it no longer was going along with the 14-year agreement. So the state initially was willing to go forward with the 14 years. However, because Mr. Phillips decided that he did not want that and did not follow through with entering a plea with regard to that, we in fact withdrew that.
So I'm sorry, go ahead. No, his position was that he wasn't going to agree to a 14-year when he'd already done everything he did for 6 years.
And that's what it seems like from the transcripts, that he felt that he had completed all of the obligations that he had under both of those agreements. Therefore, he was not going to agree to the 14 years. Correct.
So then the trial court's speaking about his ability to fully perform in the future after this order. The state is saying it won't matter. The offer has been withdrawn. Be it for the 14-year offer has been withdrawn.
And that was correct. That was on the record, Your Honor, that the state did in fact withdraw that. Yes.
So back to the final appealable order question then, because if you wipe away the last part of the trial court's order, then that's not the case, that he can't still perform. Does that not tend to make the trial court's order in this instance more of a final appealable order?
I don't believe so, in that he still has that option after the court would enter some sort of sentence, if in fact he was found guilty of the matter, that he still has that option, because he did raise the issue before the trial court prior to actually going through any sort of trial or entering a plea with regard to the issue of these plea agreements, that option is still available to him at that time after actually being convicted of any sort of crimes in this matter. So he still has that available to him after that fact. And in relation to the actual terms with regard to these two agreements, it was Mr. Phillips himself who approached the state stating, this is what I'm going to be able, I have some information about, this case. And what I'm willing to do is have my wife go ahead and contact this third party that had not been indicted and participate in a surreptitious phone call or have some sort of recorded meeting with this third party in order to gain information about, have that recording of this individual on tape. This is what he approached the state with. And the state made it clear that that obligation was something that the state wanted in order to go forward and actually comply with this agreement. At each of the recorded meetings, the state made it known that her cooperation in this recorded phone call was necessary and an obligation that the state required in order to follow through with that agreement. So it wasn't something that was confused by the court. It's plain and clear in those recordings that this was an obligation that Mr. Phillips placed upon himself. And his attorney put that forth. Mr. Phillips agreed with that notion, and his wife also in another recorded meeting stated that she would cooperate.
So the wife is the one that she first agreed to do it, and then she said, no, I will not do it.
Correct, Your Honor.
So it's how is he to produce his wife's cooperation?
And I definitely can understand that being something of an issue, but there was an alternate plan to address that situation in which Mr. Phillips would actually go forward and be able to meet that obligation.
So he would make the call?
That he would participate in some sort of recorded.
And was he given the chance to do that?
That was something that was out there that actually on the record, his attorney stated that he did not want to fulfill that portion of the obligation as well. So it's not only his wife who was that initial offer that was set forth by his attorney, by himself, and by his wife, but also the fact that Mr. Phillips didn't want to agree to this alternate plan either. So there was a second opportunity for him to fulfill it, but he indicated his unwillingness to do that. And in response to Mr. Phillips' argument that it was the state somehow did not fulfill its obligation in locating a phone number for this third party, Mr. Phillips indicated that the information, the phone number, would be a part of his phone records or his wife's phone records. The state and law enforcement actually was able to obtain those records and actually research the phone numbers in those records to try to find some sort of subscriber information, some sort of phone number to attribute to this individual. And when they did that, they were unable to find any sort of subscriber information for any of the phone numbers. And when presented to Mr. Phillips, he stated he didn't know, even when presented with those phone logs, what the phone number was. So it's not as if the state did not make efforts to try to obtain a phone number in order to make that phone call happen. But the information that Mr. Phillips provided in order for them to do so led to a dead end. Therefore, the state would argue that Mr. Phillips does not meet the obligation, did not meet all the obligations that would in fact allow him to have the specific performance of these plea agreements. And the big one that's obviously an issue here is that phone call with the unindicted third party that never took place. Therefore, the state would argue that the trial court was correct in determining that he would not be eligible for that 6-year term because of the fact that these obligations were not fulfilled on his behalf. If there are no further questions from the panel, thank you, Your Honors.
Just 2 points of clarification. July 2011 meeting between Mr. Phillips, the prosecutor's office, his attorney, it's really clear in there, you see it in the transcripts, that he's asked by the prosecutor, who can corroborate your statements that you're giving us on the information, who is behind the crime that you were involved in. He clearly says his wife. Talk to her. A month later, they meet with his wife, and she corroborates all of Brady's statements. Keep in mind, Mr. Phillips has been in jail the entire time, for nearly 2 years before that happened. The other point is, with respect to the jurisdiction, we just ask that if the court is going to issue an opinion that it's not a final appeal order, maybe just give us some guidance to the parties in the trial court as to what else needs to happen, because there's the issue of Mr. Phillips taking and passing a polygraph, which is clearly stated in the trial court's ruling. That hasn't happened yet. We have, what's not reflected in the briefs, I want to point out to the panel, is that the trial court gave us a deadline. It was March 2014, I think, March 20th maybe, of deciding whether Mr. Phillips was going to make himself available to do the willingness to do the polygraph. I did submit a motion, I think I called it or a notice of availability or something like that. He is willing to take the polygraph, so it's part of the record you'll see, but I don't think it was adequately presented in the briefs that the record doesn't reflect. He's still in jail, but he's willing to take the polygraph whenever the state provides that to him.
And when was he arrested for these murders?
December 20th, 2009.
So this case has been pending for all this time?
Yep.
Which, I know we talked a little bit about prejudice in the briefs in regard to your client. I'm wondering, again, if we allow appeals like this, they go on for a year or two, witnesses can die, evidence can get lost, doesn't that prejudice the state potentially?
Well, again, I
mean, it
understand.
could be detrimental to your client too, as far as I know.
That's right. That's right.
That
that is obviously recognized. That is a risk. And in this case, I can't speak to why. Once I got on it, I don't know why it took so long. Because you'll see in the briefs, that the initial discussions about Mr. Phillips' cooperation was in fall of 2010, but the first meeting that he participated in wasn't in midway 2011. So I don't know what was going on, to be honest with you. And I hesitated to file the appeal because I knew it was going to delay his incarceration. And I can tell you from a client's perspective, if they're going to be in prison eventually, they'd rather be in prison than jail. Jail is meant to be a temporary incarceration. Certainly 5.5 years is a long time to be in a local jail. And we don't have too many of those folks, even on the most serious cases like this, even lasting that long in jail. But we just felt Mr. Phillips didn't have any other options with respect to procedurally. So we asked the court to consider it. Again, if the court's going to issue an opinion that's not final to the board, we ask for some guidance with respect to what would have to happen in order to get us to that point.
Thank you.
Thank you.
Thank you both for your presentations this morning. Court will take the matter under advisement, issue a written decision which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website.
Thank you.